How's everyone this evening? Good. Good. The Honorable Minister of Fisheries and Communities.
Mr. Speaker, thank you. We could be making history tonight.
Why is that?
Don't we do that every night?
Well, I'm glad you asked.
Scared to ask.
Hypothetically, this could be one of the last sessions of the night for this House and this Assembly to sit.
Okay. Okay. Yeah.
New rules come into play. New rules come into play next February.
The Honorable Minister of Finance, Deputy Premier.
Oh, I hope we make history in other ways tonight too, Mr. Speaker. I move, seconded by the Honourable Premier, that the second order of the day be now read.
Shall it carry?
Order number 2, consideration of the capital estimates in committee.
The Honourable Minister of Fisheries, the Honourable Minister of Finance, Deputy Premier.
Thank you, Mr. Speaker. I move, seconded by the Honourable Premier, that this House do now resolve itself in a committee of the whole House to take into consideration capital supplied to Her Majesty.
Shall it carry? Carry. The Honourable Member from Tignish Palmer Road, Deputy Speaker, to chair the Committee of the Whole, please.
The House is now in a committee of the whole House to consider the grant of capital supply to Her Majesty. A request has been made to bring a stranger onto the floor. Shall it be granted? Good evening. Would you please state your name and title for Hansard?
Gordon McFadgen, Assistant Secretary to the Treasury Board.
Thank you very much and welcome. Honourable members, we are on page 25. Capital expenditures, transportation, infrastructure and energy. The section on capital improvements, highways was read. It was carried, but there was a question that we allowed to go back from Summerside South Drive.
Thank you, Chair. We all set? Ready? So the question that we got partway through there yesterday was that we've heard a lot that we had to do all this paving and these projects because they were the ones that were in the queue, and it would be impossible to get, say, housing projects or schools or any of the various other things that the funds could be used for done by 2021. And the question was, no? I'm sorry, I see you shaking your head, Minister. Perhaps you'd like to answer that part.
So I explained yesterday, Honourable Member, the Canada Build Fund, the projects were already approved and in the queue. That's totally different from the 80-20 funds and the resiliency fund through COVID. Two different funds.
Yes.
Summerside South Drive.
Thank you, Chair. Yeah, I understand that. But the COVID resiliency funds has a broad swath of things that qualify for it, not just paving, correct?
And we didn't use it for paving, Honourable. And we didn't use it for paving, Honourable Member.
Summerside South Drive.
Thank you, Chair. So none of the COVID resiliency fund is for any of these paving projects that were all the $50-50? No 80-20? Oh.
Summerside South Drive.
Thank you, Chair. That's fine.
Shall the section carry? Capital improvements, buildings, appropriations provided for the renovation, retrofit, and construction of government buildings and properties. Buildings, total capital improvement, buildings, $9,111,000. Total capital improvements, buildings, $9,111,000. Total capital improvements, buildings, $9,111,000. Charlottetown, Brighton.
Thank you, Chair. First, I'd like to apologize if I in any way transgressed the rules last time, but I was wondering if you could clarify a couple of questions. Is there any rule about how long a question can be?
Their take-backs from
No, there
DI,
isn't.
either to be handed.
Okay. I noticed that you allowed other members to make statements and state opinions. Is that allowed?
You have the floor. You have the floor, honourable member.
If you have the floor.
You have the floor. You can speak whatever you want. If you want to make a statement, you're free to make a statement. If you want to ask a question, go ahead.
Well, I do have a question on the net zero and how it relates to the budget. And I think I began saying that last time, that I'm very excited about the goals that the government has to reach this goal, but I just don't see anything in the budget, except for 2 schools that is not going to appear on the operable until 24, which is halfway through the 10-year period. How in the world are you going to reach that goal, which involves like tens of thousands of buildings, both built and unbuilt ones, without sort of doing something about it now?
Honourable Member, I think that's probably a question that maybe you should ask the Minister of Transportation during question period.
Charlottetown, Brighton.
Well, that's an interesting suggestion, but and I will do that. As a matter of fact, I wrote the questions already. But the matter of fact is that when you ask a question and you get the answers, they are very short, and although you might get a little bit of a laugh out of it, it's difficult to get an in-depth question. But I find it interesting that the Minister just seemed to absence himself whenever he might have held.
Honourable member, you cannot mention whether a member is in or outside of the rail.
Okay, my apologies.
So, Honourable Member, I mentioned before that every project we're doing now through the capital budget and even through operations will be through the net zero lens, that we'll make decisions that take into account that we have a goal and we're going to reach that goal, and every decision that they make will take that into consideration. So whatever that is, whether it's a build or a renovation, all of the projects that government will take on will be through that lens.
Charlottetown, Brighton.
Well, that's reassuring to hear, but I just did a quick run through and just on the building end of it, and you speak about billions of dollars over 10 years. Obviously, it's going to require more than just the government sit down and look through the lens. They're going to actually have to do something that's substantial. And if it doesn't show up in the budget in some way, one leaves one to believe that, that the government doesn't really mean what it's saying. You can't be the leader, which is what you claim to do, without taking action. And I don't see any action.
Well, I appreciate your comments, Honourable Member. We are working towards electric vehicle, replacing government vehicles with electric vehicles, putting in charging stations. There's more to this than buildings. And it's also about mitigating the amount of carbon that we're burning through, changing, doing biomass through some of our buildings, using biomass as one of our heating systems. There are a number of ways that we're targeting this. It's not just about buildings.
I completely...
Charlottetown, Brighton.
I'm sorry, Chair. I completely understand that, but if you consider that there's well over 50,000 cars on PEI, obviously electric school buses and a few chargers are a welcome thing, but how are you going to get 50 to 50,000 just by doing 50 in any particular year. There's no possible way you can do that.
Appreciate the question and the concern, honorable member, and if you have any suggestions as to how we can meet those targets, I'd be more than open to hear what they are.
Charlottetown Brighton.
And how would I do that?
Honorable member, you can reach out to the Minister of Transportation and set up a meeting, and he'd be more than happy to meet with you to discuss it.
Charlottetown Brighton.
Okay, just as for your comment with biomass, it's most experts agree that using biomass creates more CO2 than helps. But anyway, for the record, that's not my specialty. Thank you, Chair.
You're welcome. Summerside South Drive.
So, sorry, we're on capital improvements buildings, Chair?
Yes, we are.
Yes. Can we go back? We got some new information here just distributed just now, and it's relevant to some questions I asked under equipment, under the light fleet and charging stations and the like, and I'd like to go back to that if I could.
Sure.
Thank you, Chair. So, answer number 5 here in what I was provided says, one of the question was about the standing committee recommending a pilot for vehicle-to-grid technology be used for our electric buses, and the answer that we've received here is that it's currently not available on buses. And it's been very publicly announced by the actual company that we got our buses from that it is available right now and has been for some time. I've been dealing with the person who actually developed the technology for the company. They've ordered a bus before we did and had it delivered. So I'm just wondering where this information that it's not available is coming from.
The handout that was passed out is from the department, so we will circle back with them to ensure that that answer, if you don't believe is the correct one, is addressed.
Summerside South Drive.
Thank you, Chair. It's troublesome because I've dealt with the Minister of Education asking him to include this information on the tender, and he kept trying to, he told me, but he was always told by the department it was impossible. And now it's very public that it's possible, and we're still getting the same answer. So I find it troubling, and
Okay.
So I would like to have that information
Okay.
back, yes.
Appreciate that.
Summerside South Drive.
That's fine for that section, Chair.
Okay.
We back to capital.
Sure.
Okay, so another one of the recommendations from that same special committee was that government no longer invests any public funds in biomass that doesn't have a carbon cycle of less than 10 years where it's completely neutral. And as the honourable member was just mentioning, it's well documented that burning wood of any sort is not carbon neutral within that time frame. So you had come in and given us a presentation that showed that there was a $1.8 million investment in biomass going into more of our buildings. Is that correct?
That's the number we have, isn't it, Gord?
Yep, it's in the capital
Yep.
budget, yep.
Summerside South Drive.
Thank you, Chair. Is it exactly 1.8 million? Is that?
There was a strategy a number of years ago to convert a number of buildings, and this is the last piece of that strategy from 2 or 3 years ago to get, I think, 25 government buildings hooked up to the biomass.
Summerside South Drive.
And could you tell me the exact amount that's for that in this budget? Is it?
Yeah, it's the 1.833 million in the next fiscal year.
Summerside South Drive.
Thank you, Chair. So these projects, was there any way for us to stop these projects from going ahead this year, or were we locked in due to previous agreements? Or?
There was a request for proposal out for a number of government buildings. They were all identified in the RFP, and I think there's 2 proponent companies currently working their way through the list, so they're getting, this is the last run of those buildings.
Summerside South Drive.
Thank you, Chair. So when did those RFPs go out?
I believe it was in 2018.
Summerside South Drive.
Thank you, Chair. I'm okay for now.
Okay, shall the section carry? Total capital expenditure, transportation, infrastructure, and energy, 74,258,000. Shall it carry? Shall the budget carry?
Okay. Mr. Chair, I move that the Speaker take the chair and that the chair make report to Mr. Speaker.
Shall it carry? Mr. Speaker, as Chair of the Committee of the Whole House, I wish to report that the committee has gone into capital supply to be granted to Her Majesty and has come to certain resolutions thereon, which said resolutions I am directed to report to the House whenever it should be pleased to receive same.
Mr. Speaker, I move, seconded by the Honourable Premier, that the report of the committee be received.
Should it carry?
Carry. Mr. Speaker, I move that the report of the committee be adopted.
Should it carry?
Carry.
The Honourable Minister of Finance, Deputy Premier.
Thank you, Mr. Speaker. I move, seconded by the Minister of Health, that the 7th order of the day be now read.
Should it carry?
Order number 7, an act to amend the Liquor Control Act, Bill number 78, ordered for second reading.
The Honourable Minister of Finance, Deputy Premier.
Thank you, Mr. Speaker. I move, seconded by the Minister of Health, that this House do now resolve itself. Sorry? Oh, it needs to be read a second. I move, seconded by the Minister of Health, that the said bill be read a second time.
Should it carry?
Bill number 78, an act to amend the Liquor Control Act, read a second time.
The Honourable Minister of Finance, Deputy Premier.
Thank you, Mr. Speaker. I move, seconded by the Minister of Health, that this House do now resolve itself in a committee of the whole House to take into consideration said bill.
Should it carry? The Honourable Member from Tignish, Palmer Road, Deputy Speaker, the Chair of the Committee of the Whole House, please.
The House is now in a committee of the whole House to take into consideration a bill to be intituled an act to amend the Liquor Control Act. Honourable members, a request to bring a stranger onto the floor has been asked or requested. Shall it be granted?
Granted.
Good evening. Would you please state your name and position for answered?
Richard Blackear, the Supervisor of Licensing and Regulatory Operations for the Prince Edward Island Liquor Control Commission.
Thank you very much and welcome.
Thank you.
Promoter, would you like to commence with a general statement on the bill's intent?
Thank you, Chair. So the intent of the bill is to change the act so that a patron can go into a restaurant and have up to 2 drinks without ordering a meal. So because of COVID, we've changed some of the regulations around alcohol, and this is part of the act, so we have to change the act in order to do this. And it's to support restaurants during COVID, and it's something that's being done in other provinces, so very minor change to the act.
Is it now the pleasure of the committee that the bill be read clause by clause, section by section, or open it up as a whole? Okay, I'm now taking questions. Mermaid Stratford.
Thank you, Chair, and thank you for bringing this legislation forward. And thank you, Richard, for being here with us tonight. So an earlier draft of this bill had a number of other components to it, a number of amendments, and it was to loosen up restrictions for bringing alcohol into the province and for personal use, and allow the LCC to appoint an external auditor, as well as, I think that was it. Can you tell me why those amendments are not part of this anymore? Like why that's not needed?
I'd say, honourable member, that this was the one that seemed to be the, I guess, bubble to the surface as to the one that we wanted to make sure was in the Act. And I would say the other amendments probably will come forward maybe at another time, but we just, because of time constraints and just where we were, this was the one that we brought forward.
Mermaid Stratford.
Okay, understandably. And there was ask for home delivery to continue. Is that something that you foresee is going to continue, and for how long?
That will continue. The changes that we made earlier, they do not affect the Act, so it did not have to come to the floor of the legislature. So the changes were extended till December 31st, but there will be, it will continue on, basically.
Okay.
We've changed, make those changes permanent.
Mermaid Stratford.
That's fair. Thanks, Chair. So there was discussion a few years ago of a full review of the Act. Can you tell me where that currently stands?
Richard, do you?
So the review was completed, and there was a few minor regulation changes made, but the Act, we're at a stage now where the Act has to be opened and go in to make some major changes now.
Mermaid Stratford.
Okay. So the review's been completed and now it's just pending legislation? Okay. Do we have
Yes.
do we have an idea as to like how long it'll take that legislation to come forward?
I'm not certain what the timeline is.
Okay.
Mermaid Stratford.
Okay. So we had done a tour. I'm just wondering, like when you did that review, we'd done a tour and we'd visited a number of breweries, wineries, and cideries, and they have significant challenges with some of the regulations. As part of that review, were they consulted? And if not, is that something that can be done prior to legislative changes if there's more that needs to happen?
There was a survey done with all the license holders. There was an opportunity for them to send their ideas along to us, and that was all put into the review.
Okay.
Mermaid Stratford.
I think I'm good, Chair. Thank you.
You're welcome. Leader of the Opposition.
Thanks. Just to see if we can get a firmer timeline on that review. I heard what you said, that you reviewed the current Act and decided that rather than try and make some amendments to it, you're doing a complete rewrite. Is that a fair statement to say?
Yes, because as some people would know, the Liquor Control Act was written back in like 1947, so it was time for a review.
Leader of the Opposition.
Can't disagree with that, Chair. And yeah, I too. I mean, there are a number of areas where its age is definitely showing. And we've made amendments along the way, and on this side of the House we've brought forward some suggestions to change regulations, which to be fair have been done. But I absolutely agree that a full rewrite is the only sort of kind thing to do in this case, not just to the Act, but for Islanders. So is this something that you imagine happening in the next year and the next 2 years? Can you give us any sort of sense of how long that might take?
I would hope it would be, sooner rather than later, but I know there were a number of challenges. We did try to, be, I guess, responsive to the challenges during COVID, and we did make some changes just to help a number of our vendors with, delivery to homes. Restaurants can now deliver with food, and so we realize that it's on the list. We're just not quite there yet. So.
Leader of the Opposition.
So is that rewriting of the Act, is that something that has started at this point?
No, it hasn't. No.
Leader of the Opposition.
My guess is it's going to take some time then. Is there a particular province in which you're basing the potential rewrite here, or is that too early to ask that question?
It might be a little bit too early to ask that question.
Leader of the Opposition.
And just one final thing, in terms of sale of liquor in convenience stores, is that something that can be changed in regulations in the current Act, or would that have to be part of a complete rewrite of the Act?
That would have to be, you would have to go and open up the Act to do something like that.
Leader of the Opposition.
So we should not expect that to happen anytime soon then? Not
That
advocating
timeline
for it,
would-
I'm just trying to be clear, because I'm being asked by a number
Yeah.
of convenience store owners.
That timeline would, I wouldn't be able to answer that. That would be for someone else too.
Okay.
Leader of the Opposition.
Thanks, Chair. So in a specific case, if you have a convenience store owner, just theoretically, and in your district, who's been asking you for some time when they may be able, just, let's imagine. For an individual case like that, is that something that requires the opening up of the Act as well, or can you grant a license to a particular convenience store without having to do that?
My understanding is the only model that we could use would be an agency store. Am I correct with that, Richard?
Yes,
Yeah.
yes, Minister.
Leader of the Opposition.
And an agency store, would that require opening up the Act, or do you just add a name to the list of agency stores?
I think there would be a call. It wouldn't just, it
Sure.
wouldn't just.
Yeah,
there-
absolutely.
There would be a call, and we could do that, is what I'm assuming, because it was done before through, we have agency stores, so, yeah.
Leader of the Opposition.
And so I'm just trying to clarify, if that were to happen, if a call went out, that would not require a rewriting of the Act in order to do that?
That's my understanding, because we have 6 agency stores, so that's already something that's been done, so. But selling in convenience stores is a different model, totally.
Leader of the Opposition.
So to add an agency store, is that something you have planned to do, or agency stores, I should say? Is that something that you have planned to do in the foreseeable future?
We are considering that, Honourable Member, and I will use the COVID excuse for this, and it's probably not a good excuse, but it is something that we have been looking at, and I will definitely be pushing for some kind of a decision in the new year on whether we do that or not.
Leader of the Opposition.
So the hypothetical owner of the hypothetical store, what should I say to that hypothetical person?
You may want to say to that hypothetical person that the minister said hypothetically, that there could be an RFP go out, or an MOU for agency stores, and that if he's interested or she is interested in that they should just keep in touch with their MLA.
Leader of the Opposition.
I think I'll stop there. Chair, thank you.
O'Leary Inverness.
Thanks, Chair. Minister, I was a former minister of that portfolio as well at one time, and I certainly understand. I think at that time there was a lot of talk about issues around the Act and how outdated it was. And but it is a rather complex Act, and to try to get it right. And sometimes as a minister, you're not in these portfolios for all that long, and you're trying to make some changes, which is why we pursued the agency store model in greater length, and I will say that generally has worked well, but I think there's also a point of diminishing returns on that. I mean, in the end of the day, you may increase your sales somewhat, but it's not in proportional that it's 100% new sales. It takes from somewhere else, so you have to try to find that balance. And a lot of our liquor store commission stores, they're staffed based on the volume of sales, and so it does have impacts far-reaching in trying to make those decisions. But do you feel in this legislation that this will increase drinking or sales somewhat, or is it a trade-off, dollar for dollar, or beer for beer? What's your opinion on that?
I don't think there's going to be a major change. If you talk to people, I think a number of people wouldn't even know that they couldn't order two drinks, but it's making it legal, and I think that is just one way of supporting, restaurants in the time that we're in now, but it's also, bringing us forward a little bit with modernizing what we do, and the example I would use is, you go and meet some friends, and maybe you've already had dinner, but you want to have a drink with them, or two. So now you can do that, but it's not unlimited. It's up to 2 drinks. So it's not going to compete with bars, but it gives restaurants an ability to serve up to 2 drinks.
O'Leary Inverness.
And in general terms, I would say I I can support this. I don't have necessarily a big problem. And I say, as a minister, I kind of felt we needed to open up the act a bit more, and I think I was responsible. We did some stuff around boats and things like that. But on the other side of it, your Minister of Attorney General, he seemed, and yourself, you gave a very passionate speech about drinking and driving and the challenges that that's facing. It would seem to me that this legislation would probably put a greater risk that could happen, just to say 2 drinks. You might have had 2 drinks before you went, and then you go to a place and you have 2 more, and then all of a sudden you got to get from this restaurant to wherever you're going to get back home at some point. So are you concerned at all that might have some impact based on the passionate speech that you gave?
Honourable Member, I think what I would say about that is people are responsible for their own actions, and I will continue to say that, regardless of what it is in life. And I see this as no different. And they could go to a bar and have 10 drinks and probably be served, whereas they're going into a restaurant maybe to meet a friend, and they can have up to 2. It's still their responsibility to make sure that they have a driver and that they're going to adhere to the law. So I don't see it. I've never been a proponent for making anything available makes it increases the risk. People are still responsible for their actions. So that
O'Leary Inverness.
And I agree with you. You and I have had many conversations on different subjects. We do seem to have similar mindsets on some of these things, but we both represent rural ridings, and so I get all that. But I just wanted to kind of raise that awareness. As a person sitting over on this side of the house, when I hear those kinds of speeches and those kinds of comments, legislative motions that seem to be trying to make it more harder on the drinking driving issue, and then we're kind of going the opposite the other way. It just sort of seems a little odd. But anyway, I generally understand where you're coming from. I generally would believe, like you, that people need to be responsible. It's not up to us legislators to prevent everything and people from making totally irrational decisions. They have to be responsible for those decisions and make them. And this can support a restaurant industry while not having big impacts on other industries out there. I can generally support that. So I just want to make that comment. Thank you, Mr. Chair.
You're welcome. Cornwall Meadowbank.
Just one quick question. I think I asked you this before, but I'd go on and on about the Liquor Commission, but I won't tonight. The 25-cent distribution tax for the craft brewers. When your department doesn't touch the liquor and they're delivering it themselves and they're still paying the 25%, 25-cent tax per liter. Is there any way you can take that off for them to make them more viable, especially throughout this next 3 or 4 months? It's going to be tough enough for them, I think.
I think there are a number of things that need to be looked at, and how we tax breweries versus any other establishment is one of them, and I think that will all be part of what we look at when we open the act and change it.
Cornwall Meadowbank.
And just one quick, on the Canadian Free Trade Agreement, there's different areas in there and different policy from moving liquor from province to province or ordering wine to BC, and it was complicated with the law case that was in New Brunswick at the time. Has there been any changes or any movement to allow more freedom in that regard?
Can you answer that, Richard?
Well, moving it from province to province, every jurisdiction has their own rules, and each province respects the others. So right now, it's I think it's only Manitoba and British Columbia where you can order online. Is that what you're asking about, the online ordering?
Yeah.
Okay, so right now, if you order online, only Manitoba and British Columbia allows that. All the other jurisdictions don't.
Yeah,
Cornwall Meadowbank.
that's what I meant, the free trade. That's what the free trade was supposed to open up, to allow that. So if it's Hop Yard, or not maybe Hop Yard, they don't make beer, but another brewery, Bogside, wanted to sell into, yeah, okay.
So they would petition, they would contact, if it was New Brunswick, they would contact New Brunswick and ask for permission. And to date, like I said before, it's only Manitoba and British Columbia.
Okay, thank you, that's fine.
You're welcome. Charlottetown Brighton.
Oh, yeah, I generally support the intent of this law. I think the liquor law is full of all of these little irritating rules. So my only disappointment that you don't get rid of more of them. I'm bringing up one in particular doing the, where you're allowing restaurants to deliver food, takeout that could be delivered, but you could only get a whole bottle of wine. You couldn't have a glass of wine, for instance. You could have a cup of coffee, but not a glass of wine. So I'm wondering why you haven't included more things like that.
Well, then you get into someone carrying open liquor when they're delivering it. That would be one, I guess, hitch in that, and I don't think it's something that the Liquor Commission is going to entertain, having, putting it out there to restaurants that you're going to have a delivery person delivering open liquor. As long as it's bottled, so you can have coolers and you could have single-serving bottles of wine, I guess, but you cannot have open, pour it into a glass and put a cover on it. You can't do that. So it's not something that we're entertaining right now, for sure.
Charlotte Brighton,
Thank you.
leader of the third party.
Thanks, Jeff. Just a quick question. So, if I understood it correctly, there was mention of the act was established in 1947.
1947, yeah,
So there's been many changes since then.
there has been.
But has there been a complete overhaul of the act?
No, and it was probably, it's been completed now for probably 12 or 18 months now.
Leader of the opposition, sorry, leader of the third party.
What spheres a change like this? Like, is this coming from the industry, or is this coming from people from within?
Okay, so this was, the proponent for this change was coming from Restaurants Canada Atlantic, and then it was supported by the Association of Prince Edward Island too, as well as all the other dining room license holders on the island. It enhances their operations a little bit.
Do you
Leader
have
of
any
third
idea
party?
how many license holders there is that have dining rooms in PEI?
Pardon?
How many license holders are there?
Approximately 187.
187.
74 seasonal.
Leader of the third party.
187 premises, 74 of those are seasonal.
Okay. Thank you very much, Chair.
Welcome. Charlotte Brighton.
I'm sorry, I just have one more question. I noticed that the Superstore in Charlottetown has a beer store, basically. And I was just curious, is that an agency store or is that considered a brewery? How in the world did they get that there and nobody else has it?
Maybe you should ask the member from Cornwall Meadowbank. Maybe you should ask the previous administration. Yeah, intervention.
What about the interventions over there?
Yeah, it's called a microbrewery. I have no idea is my answer.
You want me to answer that for you?
Sorry.
Do you want me to answer?
Sure, Richard will answer it.
Okay,
He'll give you
so-
the formal answer.
So the Gahan Superstore operation, they have a manufacturing license there where they ferment beer, right? So if you have a manufacturing license, you're allowed to have one retail outlet, and that's where it is. That's why they're allowed to do what they do there.
Charlotte Brighton.
Well, you wonder why there's nobody else gotten onto that?
I don't really, I can't really answer you. I can't answer for the other license holders.
Charlotte Brighton.
What I was suggesting, if that unknown corner store, got a connection with a brewery, could they legally put on a retail store within their store?
There would be parameters around that.
Yes,
Yeah.
they would have to be doing some type of manufacturing there, distilling or fermenting or something in order for that to have that same setup as the Gahan Superstore does.
Okay, thank you.
Charlotte Brighton.
Thank you.
You're welcome. Summerside South Drive.
Thank you, Chair. And I picked up on part of what Cornwall Meadowbank and your answers were there, but did you say that in regards to like the no touch, no tax that I've been hearing the local brewers calling for, like normally the Liquor Control Commission brings in alcohol and it has some handling fees and things like that it would have to recoup, and there's nothing like that going on whenever there's direct sales going from the brewery to the public. So is that the kind of thing that you were talking about when you open up the Act and have a look?
Very well aware of the issue, Honourable Member, and it's something I think that would be part of what we looked at, just about the taxation around any whether it's beer, wine, or alcohol on Prince Edward Island. I mean, every part of the act would be, reviewed.
Summerside South Drive.
Thank you, Chair. And did I read something about wine in parks coming? Were you in a story about wine in parks, something like that?
About drinking it? Or- No, sorry, go ahead, Richard.
Are you referring to open alcohol
I
being
suppose I am,
consumed
yes.
in public? That didn't really take off, I don't think. There was some talk about it in the municipality of Charlottetown, that they were looking at something like that, but we were never approached to look into it or anything like that.
Summerside South Drive.
That's great, Chair. Thanks.
You're welcome. Shall Bill Carey.
Yes, nice socks, Richard. We're on camera.
Honourable members, we're still in session.
I move the title.
An act to amend the Liquor Control Act. Shall it carry?
I move the enacting clause.
Be it enacted by the Lieutenant Governor and the Legislative Assembly of the Province of Prince Edward Island as follows. Shall it carry?
Mr. Chair, I move the Speaker take the chair and that the chair report the bill agreed to without amendment.
Shall it carry? Mr. Speaker, as Chair of the Committee of the Whole House, having under consideration the bill to be intituled an act to amend the Liquor Control Act, I beg leave to report that the committee has gone through the said bill and has agreed the same without amendment. I move that the report of the committee be adopted.
Shall it carry? The Honourable Minister of Finance, Deputy Premier.
Thank you, Mr. Speaker. I move seconded by the Minister of Health that the ninth order of the day be now read.
Shall it carry?
Order number 9, Children's Law Act, Bill number 57, ordered for second reading.
The Honourable Minister of Finance, Deputy Premier.
Thank you, Mr. Speaker. I move seconded by the Minister of Health that the said bill be now read a second time.
Shall it carry?
Bill number 57, Children's Law Act, read a second time.
The Honourable Minister of Finance, Deputy Premier.
Thank you, Mr. Speaker. I move seconded by the Minister of Health that this House do now resolve itself in a committee of the whole House to take into consideration the said bill.
Shall it carry? The Honourable Member from Tignish Palmer Road, Deputy Speaker, to chair the Committee of the Whole House, please.
The House is now in a committee of the whole House to take into consideration a bill to be intituled Children's Law Act. Honourable members, a request has been made to bring strangers onto the floor. Shall it be granted? Good evening. Would you begin by introducing yourselves with your name and title, please?
My name is Claire Henderson. I'm the Director of Family Law and Court Services with the Department of Justice and Public Safety.
Blair Barber, Legislative Specialist with Justice and Public Safety.
Thank you very much and welcome. Promoter, would you like to commence with just a general statement on the bill's intent?
Yes, I would, Chair. This bill modernizes family law for kids laws related to parenting time, parental decision-making, responsibilities, who can have contact with the children, child support, and parentage is all in one piece of legislation. It focuses on the best interest of children. There will be clear legislative requirements for courts to consider what is best for the kids, the impacts of family violence on children and the family, innovative ways to resolve issues outside of the court system. Also, this act works alongside and updates made by the Federal Divorce Act. Thank you, Chair.
You're welcome. Is it the pleasure of the committee that the bill be now read section by, or clause by clause, section by section, or open as a whole? Section by section. Okay. Section 1. Shall section 1 carry? Leader of the Opposition.
I'm just wondering if one or both of the strangers could give us, well, section 1 is definition, so perhaps not particularly relevant here, but certain members of our caucus were present for a very thorough briefing a little while ago, a week or so ago, but not all of our caucus. And I think for those of us who weren't present at the briefing, and also to have it written in the record, it would be very useful to have at the beginning of each section. Again, this section may not be the most applicable, and I'd be willing to pass by this section personally. I know we have some questions on it, but when we get to the other sections, if you could give us, or the parts rather, I know it's divided into parts, what the intention of those parts are, and how and what changes this brings to the judicial framework here on Prince Edward Island in terms of children. Thank you, Chair.
Okay. Shall this section carry? Summerside Wilmot, sorry, I didn't see you.
No problem. Thank you, Chair. I just have a quick question for you. I see under definition H, decision-making responsibilities. Could you elaborate on examples of significant extracurricular activities?
So the changes that are being made in this definition section are actually in response to changes that were made by the federal government in Bill C-78, an act to amend the Divorce Act and other acts that are related to the separation of families that are legally married. And one of the most significant changes that has been made to that act, and consequently to this one, is terminology like decision-making responsibility. So where previously we would have used terminology like custody and access, decision-making responsibility, parenting time and decision-making responsibility is what we would now say instead of custody. And access to a child would also refer to contact with a child. And so significant extracurricular activity, that part of the definition aligns with the changes made to the Federal Divorce Act. And one of the issues is that this is a new definition. And so that particular piece will likely be the result in some interpretation by the court about what exactly constitutes a significant extracurricular activity.
Summerside Wilmot.
That answers my question. Thank you, Chair.
You're welcome. Shall this section carry?
Quick question.
Mermaid Stratford.
So, can you give an example, though, of a significant extracurricular activity?
So I would expect that it would include things like a child being involved in hockey, rather than a child engaging in, some people like myself love to read. And so that would be something I would do outside of school, but it might not, while significant in terms of its impact on a child's happiness, would not necessarily, I would expect, be interpreted as a significant extracurricular activity.
Mermaid Stratford.
Okay, I'm good. Thank you, Chair.
Shall this section carry? Okay. Section 2. Questions on Section 2. Leader of the Opposition.
Thank you, Chair. And I neglected to say this in my first comments, but I want to thank you for your patience. I realize you have been sitting waiting for this moment through a number of sessions as we debated the capital budget, so I want to thank you for your patience to rebut here.
Henderson's, I got patience.
On Section 2, the application of the Act, there's reference to the United Nations Convention on the Rights of the Child, and I'm just wondering whether you can give the House a sort of broad overview of what the objectives of the UNCRC are.
So the primary objectives of that convention is to ensure that the actions of government and states that align with the convention are always considering the best interests of children and the impact that decisions that governments make in terms of both their law and programs, consider the impacts of children. And if one was to take the time to review the convention, and I should point out, we incorporated that section into the Act after feedback with our consultation with the Child and Youth Advocate. And in reviewing the Act, if you look at particularly the clear imposition in the legislation of a significant consideration set out in Section 33, which we'll get to later, there's really specific detail about what constitutes what the court should be considering in terms of making decisions about the best interests of the children. And if you go through this Act in its entirety, we would suggest that this piece of legislation in particular very much considers the sections and the pieces of the UN Convention, because in every instance, the primary consideration for the court in making decisions surrounding the parenting time, decision-making responsibility, and contact with children, the overriding consideration that the court has to ask itself is, what is in the best interest of the child? And so while that has always been the case because of the court's inherent, what would be called a parentis patriae jurisdiction, this makes it clear not only to the court, but also more importantly, in some ways, to the parties, to the parents that are coming before the court, that it doesn't matter what their conflict is, what the primary consideration is, how is the decision that the court is going to make going to impact the child. And so that legislative change prompted by the changes made by the Divorce Act is very much in consideration of the rights of children.
Leader of the Opposition.
I really appreciate that explanation, Claire. Thank you. And I'm also very pleased and not a bit surprised that when you spoke to Marvin that he would like that reference to be in here. He's somebody who's spent his whole life applying the UN Convention on the Rights of the Child to the work that he's done, whether that be as a child advocate now or where he was previously or the other things he's done. And so could you tell us how the UN Convention is currently reflected in perhaps other pieces of legislation here on Prince Edward Island?
My area through the department specifically relates to court services and the public family law programming. And so for the purposes of this bill, I think it's important to point out that the Children's Law Act relates to private law matters between parents and not government intervention with children. So this is very much different than legislation like the Child Protection Act. This is about providing a framework for the law in the province for private court action between parents of children that are separating. And so the rights of children that are enshrined in here would be different in terms of the operation of this act.
Right.
Leader of the Opposition.
And I understand that. And I'm just wondering whether in the other suite of acts that we have here in the province, maybe Blair would have an idea of that, if there's any attempt to incorporate that UNCRC into other pieces of legislation that we have, either currently or in the future.
Of course, our work is limited to justice and public safety. And I'm going by memory here. I think the Child and Youth Advocate Act may have a reference to the UN Convention, but I'm not familiar enough with the other legislation administered by other departments to be able to comment on what they may have.
Okay. All right.
Leader of the Opposition.
And that's fine. One of the other UN declarations is under the United Nations Declaration on the Rights of Indigenous People. And that has several articles that address the rights and the needs of children. And it's complementary in many ways to the UNCRC. And I'm wondering if there's any reason why that particular United Nations declaration is not included in this Children's Law Act.
Well, if you were to look at Section 33 of the Act, which sets out the specific considerations that the court must turn its mind to in relation to the best interests of children, you'll note that in subsection H, the court is required to consider, and this is on page 20 of the bill, the court is required to consider the child's cultural, linguistic, religious, and spiritual upbringing and heritage, including Indigenous upbringing and heritage. And so the overarching theme of the bill is that the consideration of the court has to be the best interest of the particular child in light of their particular circumstances. And so that best interest consideration is informed by the cultural piece as well. And the considerations in relation to the particular child are about the particular needs of that particular child. And that's why the UN Convention in relation to the rights of the child, all of these things are informed by the cultural perspective as well. So that's why the Act was drafted in this fashion.
Leader of the Opposition.
That's a very clear answer. Thanks, Claire. I'm good for now. Thank you, Chair.
Mermaid Stratford.
So I'd just like to ask, anybody who's already got I guess, an arrangement, a custody arrangement, you wouldn't call it custody arrangements anymore, you'd call it, I guess,
Parenting time, decision-making, responsibility, and contact with a child.
Okay.
Rolls off the tongue.
It does.
Yes.
Not yet, but I'm sure it will. So how does this impact any of those arrangements that are already struck and in place?
So at the back of the bill, you'll note that there are transition clauses that relate to how the operation of the existing law will be impacted when this bill comes into place. And so effectively, kind of the Twitter version is that any existing order continues to have the same effect as though it was an order issued under this bill. There's also a specific clause that says that the coming into force of this bill does not constitute a change in circumstance that would necessarily give the parties that may be litigious an opportunity to try and get the court involved again in ways that might negatively impact the child. And so later in the bill, there are specific sections. Basically, if you have an order that says custody and access, if and when this bill comes into force, you can read your order as though it says parenting time, decision-making responsibility, and contact with the child.
Mermaid Stratford.
And if there were folks who had issue with current arrangements, does this, I guess, enacting this new piece of legislation, would that give them the ability, though, to readdress situations that they're unhappy with in current, I'm going to keep calling it custody arrangements. Okay?
I know, it's challenging.
Yeah, I'll get there, though.
So under the current legislative regime and under this legislative regime, if you go, for example, to Part 5, there are specific provisions that allow for any party to an order issued under either act to request something called a variation order. And so if there is a change of circumstance that may be impacting the appropriateness of a existing order, the parties have the right to ask the court to consider changing the order that's before the court. And so if this act comes into force, for example, on March 1st, and on February 25th, I got an order from the court, I couldn't say I get to go back to court on March 2nd because there's new legislation. But if my circumstances changed and I needed to ask the court to reconsider the stuff that was in the previous order, this act permits that. The same way the Custody Jurisdiction and Enforcement Act or the provisions in the Family Law Act would do now.
Okay, thank you.
Mermaid Stratford, is everything? Okay. Shall this section carry? Section 3, Summerside Wilmot.
Thank you, Chair. So, under subsection 2, protecting the children from conflict, I definitely have heard from a number of parents who were quite stressed about the amount of conflict their children were exposed to in this process, as I'm sure you can imagine. And I was just wondering if you could clarify for me what is meant by protecting the children from conflict. What is conflict for the purposes of this subsection?
So this entire part of the legislation contemplates letting parties that are involved in the court system, parties being the people that are making applications, being the lawyers that are assisting with applications, being dispute resolution professionals, and the court. It's drafted so that there is an understanding by everybody that's participating in a children's law proceeding that all of the actions that are being taken need to be taken in a way that considers the fact that the court process is always has an impact on a child, regardless of whether or not the two parents are in conflict with each other. The intention of this is basically, in layman's terms, to say to parties that are litigating matters before the court, just because you have conflict with each other, just because you're arguing about what the court should do with your parenting time decision, you should do everything you can to make sure that your child is not impacted by the fact that you're litigating under this section. And so one of the things that this act does that we are very excited about is allows for the creation of a more accessible way for parties to resolve disputes without having to go to court. And even more importantly, it allows for a number of mechanisms that allows the court to consider circumstances where there may be power imbalances or family violence between parties. And so the overriding theme of this legislation is that the breakdown of families should happen in, wherever possible, a way that doesn't impact the well-being of a child.
Somerset Wilmot.
Thank you, Chair. Thank you for that explanation. So it's less about protecting from dispute between the parents in the home, but more about the process. Is that a fair assessment?
So often you will find that parents who are engaged in high conflict matters in court, those matters often trickle down into the home. And so the overarching theme of the legislation is to create mechanisms and prioritize for anybody involved in a matter that involves children and in private law between when someone goes to court to ask for a parenting time decision-making responsibility and contact order, that at front of mind, it is this conflict needs to be with the court and not in your home.
Somerset Wilmot.
Thank you, Chair, and thank you for that answer. Ensuring that quality of life isn't unduly affected for children is of incredible importance to all of us. I appreciate your time. Thank you.
Charlottetown Victoria Park.
Thank you, Chair. I just want to start out by thanking you. I know that 2-hour briefing, I was expecting it to be like an hour, and I don't know what I was thinking. But I have to say, I didn't know that someone could feel as excited about a piece of legislation as I was the more I heard about this one, you know. But so it's nice kind of catching up as a province, and really happy with the extensive consultation that was done. And really happy to see that the separation of marriage and common law is kind of seen as the same thing now. So there was a few parts of that. So just a question on the resolution of dispute through dispute resolution process. I know that when we were talking about this, there were different options, and I would love if, I don't expect it to be in as much detail as it was with us in that 2 hours, but for the parts, because there was something where you explained about the different options and how someone would make a decision on whether family violence had happened or whatever. But in this particular one about the resolution of dispute, I'm wondering, are there different options available for this?
So that's actually a bit later in the bill. There's a whole section in Part 3 about the resolution of children's law disputes. And so...
that's okay, we'll wait till we get there then. Thank you, Chair.
You're welcome. Shall the section carry?
Carry.
Section 4, Summerside South Drive.
Excuse me. In Section 1A, it says that lawyers are required to encourage parties to resolve issues through a dispute resolution process. Could you explain the different options of dispute resolution?
Again, there's more detail about dispute resolution later in the bill, but ultimately the duty of a lawyer following the passing of this legislation is to ensure that the parties are aware that the court system is not the only way for them to come to agreements about how to resolve children's law disputes. And again, in a way that we're very excited about. We are taking some really innovative steps to allow for greater mechanisms for dispute resolution that allow not only for the kind of amicable resolution of things without the court having to be involved, but also to allow parties to resolve disputes in ways that will ultimately have the same effect as a court order. So again, I can go into detail now, or we can talk about it in part 3.
Summerside South Drive?
Thank you, Chair. So these innovative solutions we'll get into in part 3?
Yes.
Yes, okay. That's fine then. How many cases in PEI are resolved by dispute resolution before proceeding to a court?
PEI is actually a very, we're a leading jurisdiction in Canada for the way that we deal with family law. Being a small jurisdiction, we're able to deal nimbly with things, and the court here is very much forward-facing about how to resolve things. So I don't know that I could give you specific numbers, because in PEI, all cases that come before the court in family law are required to go through something called a pre-motion conference proceeding, where we actually engage in judicial dispute resolution. So before parties actually go to court for an official hearing, they sit in a meeting where a judge tries to help them mediate solutions. It's awesome. And we were leaders in the country because of initiatives taken by our Supreme Court to try and assist parties with coming to resolutions. On top of that, for example, the Family Law Centre has a free child-focused mediation service that's available to families in the province. We have any number of things. And ultimately, if parties come to agreement, they don't always end up with a court order. And so I couldn't give you a specific number.
Summerside South Drive.
You might not be able to answer this next question then. Is there a target for the percentage of cases you'd like to have resolved through dispute resolution? Are there metrics that you target, or is it just
Honestly,
as many as possible?
Our target is 100%.
Yeah.
I would absolutely love to put the Supreme Court almost out of business. Like, let's be honest, if parents could resolve things without conflict, would be absolutely happy to do that. I don't know that that's a realistic goal, but that's the one we're going to continue to work towards.
Summerside South Drive.
Thank you, Chair. So under Section 1B, it says, under this section, a lawyer is required to advise their client of the family justice services that are available. Could you provide examples of such services that are available at the moment?
So we have the child-focused mediation service. There are also a number of lawyers across the province that engage in mediation and alternative dispute resolution. There are private mediation practitioners that provide support to parents. The Children's Lawyers Office in the Department of Justice and Public Safety has a parenting coordinator that provides parent coaching and parenting coordination services to parties. We have the Child Support Guidelines Office that works with families to come and attempts to come to agreements in relation to child support for the purposes of obtaining consent orders. And we have a number of other things that we're attempting to innovate on when we get to part 3.
We'll do that later. Okay,
Summerside South Drive.
Good, Chair, thanks.
Shall this section carry?
Carry.
Section 5. Shall Section 5 carry? Section 6. Charlottetown Victoria Park.
I really think that the possibility that families can separate despite, what might be going on without going to court, really fantastic. In the briefing, we talked briefly about, and I didn't catch everything, but we talked about child support and how, about the calculation of child support and how complex that was, and that it was something that no other jurisdiction has done. There's no timeline. But was that, can you explain, that was like an automatic calculation?
Right. So, and that's actually in Section 7.
Okay, let's pause then, unless you want to, yeah, we'll pause.
Okay. Any other questions, Section 6? Shall it carry?
Carry.
Section 7.
So,
Any questions? Charlottetown Victoria Park.
same question.
So Section 7 is an update to an existing provision in the Family Law Act, which allows for the administrative recalculation of child support. We have drafted this particular section so that it contemplates our ability to allow for the administrative calculation of support. The difference being, in order for someone to avail of administrative recalculation, currently they have to have a court order that the administrative recalculation officer can recalculate. It has to be eligible for recalculation. And right now, there's not a mechanism that we can cleanly allow for the administrative calculation of support. And that means if there are two parties that want to have the child support established and it's not complicated, we don't have a mechanism to allow for that. And it is, as the law often is, a little bit complex because, for example, if you are self-employed and you are a fisher or you have your own business, it's not as simple as getting your notice of assessment and then looking at line 150 of your tax return and doing some math. There's complicated things about tax deductions and things that honestly make my eyes glaze over. But we have drafted this so that while we continue to work on trying to figure out how we can make this possible, it will allow us to establish the administrative establishment of support. We have another thing that we're working on, again, under the dispute resolution mechanism. So this also will allow us to designate an employee who could do what we are calling child support adjudication. And so there are a number of people right now who are engaged with the court system because, as I said, there are exceptions to the type of support orders that can be administratively recalculated. And so if you are a fisher or you are self-employed or you have something called a shared parenting arrangement, the administrative recalculation officer cannot calculate that child support because it's complex. We contemplate having a person that has a financial background and interest in the complexity of that child support calculation. And so we anticipate that in the coming months, we would have the opportunity to have someone referred to the child support adjudicator who could recalculate their support without having to go to court, which may sound not thrilling, but would have a huge impact on the demands on the court system, and also not require the parties to potentially pay lawyers to go to court. So huge from an access to justice perspective.
Charlottetown, Victoria Park.
Absolutely, and I really appreciate that because recently access to justice has been one of the hugest things that I've been hearing about. And so this particular bill, one of the reasons that I got excited about it. One of the questions that the leader of the official opposition had asked is like a quick Coles Notes version of each part. I'm just wondering if because I did find that helpful. And I don't expect as much detail as we got. I just want to be clear that way.
So part 2, as I said, is basically a continuation and an expansion of the current child support services that we offer at the Family Law Center, so the administrative recalculation of support and also the establishment through the legislation of the Child Support Guidelines Office, which is the office where we provide the free service across the province, where we have staff who provide information and assistance to help parties make applications to the court to establish and vary child support. So this is a continuation and expansion of the existing legislative scheme.
Charlottetown, Victoria Park.
Thank you, that's all, Chair.
Mermaid Stratford.
Thank you, Chair. So in this section under the Child Support Services Office, that recalculation, is that something that happens often? I guess, I think my question is it's basically, it's a table that's used, I think, that has the complicated formula, and then you would add in what the party's salary is, and then it calculates. Does that table get updated on some sort of frequency?
So the child support guidelines that are used by PEI are the federal child support guidelines, and those child support guidelines are established and reviewed every 5 years, and that's done through a extremely comprehensive process that involves a number of experts and appearances and things like that through federally. And so again, that process is updated about every 5 years. They were last updated in 2017. The Administrative Recalculation Service is used for eligible orders. So again, not every child support order is eligible for recalculation. And honestly, not everybody who has an administrative recalculation provision in their order avails of the service. Because from time to time, parties don't seek to have their orders updated. They're content to use the amount that's in the original order, and they do that for years. So ultimately, it's up to the parties to engage with that process, but if their order is eligible and they wish to have it administratively recalculated, they file it with our office, and we have a min-recal officer that does that work.
Mermaid Stratford.
Okay, and thank you. And so I think you came to PAC and we talked a lot about maintenance enforcement and how many cases there are. Would you mind just sharing that? Because I think that that's important for Islanders. Not everybody tunes into PAC. I don't know why, but anyway, I find that hard to believe. But can you kind of just give us a summary of how many cases you actually deal with through your department? Because it's quite significant, right?
So the maintenance enforcement program is separate from the Children's Law Act and the provisions under here, but we have about like between 1,500 and 1,700 files that are enrolled with the program. It's a voluntary, neutral service that's provided by, and a free service that's provided by the Department of Justice and Public Safety that assists parties with the collection and disbursement of child support. And so we are a neutral order-based service that has a number of tools in the tool belt to try and collect and disperse not only child support, but also spousal support. And the service, you know, as we sometimes say, we cannot guarantee collection of support because the maintenance enforcement program can only collect lawful income sources, but any party who has a support order in Prince Edward Island or through something called the Interjurisdictional Support Act, parties from outside the province can register support orders for enforcement through the maintenance enforcement program or withdraw those orders.
Mermaid Stratford.
I appreciate that. So in this section, so you had said parties would have to ask to have a reassessment done if the tables were updated, etc. How would anybody know though that there is a change?
So the recalculation doesn't happen on the basis of an update to the child support guidelines. The recalculation happens on the basis of a change of income for the parties. And so if, for example, someone has a annual salary adjustment at their work, they would potentially have a change to the amount of child support that they are obligated to pay. And so the recalculation actually can happen once annually. And, you know, from time to time, someone may change jobs or lose a job, or there's a pandemic and there's a change in financial circumstances. And so it's the change in the financial circumstances of the parties to the support order that triggers the recalculation, not any change to the child support guidelines.
Mermaid Stratford.
Okay, and then just one other question. Can you give me a sense of, so you said there's complicated ones that wouldn't fit under here, right, that would be done. Can you give me a sense of what percentage would be that complicated number of orders versus, you know, your kind of regular, easy to, that would fit in nicely to this section?
I would be guessing, I would say currently it would be over 50% of the orders are not eligible for recalculation. And that's because the majority of people who have parenting time, decision-making responsibility, and contact orders would be in something called a shared parenting arrangement. And that's where people share equally the parenting time and decision-making responsibility, rolls off the tongue, of a child. And so where, you know, there's kind of a 50-50 split of custody, that's where there's not actually an eligibility for administrative recalculation, because that child support is calculated as what is referred to as set-off between one parent's obligation to pay support to the other parent and then the other parent's obligation to pay support to the first parent.
Okay.
Member Maid Stratford.
I'm great. Thank you, Chair.
Shall this section carry? Section 8. Shall Section 8 carry? Section 9. Shall Section 9 carry? 104. Section 10. Question on Section 9? Leader of the Opposition.
Oh, sorry, it's Summerside South Drive.
Sorry, okay. Summerside South Drive.
Thank you, Chair. This section creates a requirement to provide complete, accurate, and up-to-date information. Is this frequently an issue in proceedings?
I don't know that it's I would call it frequently an issue in proceedings, but so this section, this part of the Act is where we talk about the ability of parties to resolve disputes out of court. And so one of the fundamental requirements of being able to resolve a dispute is that the dispute resolution professional or the parties have all of the information that's necessary to make a decision. And so this section is in place so that it communicates to the parties that it's important for them to be honest and forthright about all of the issues in order to come to an appropriate resolution that's in the best interest of the child.
Summerside South Drive.
Thank you, Chair. So is there any information in particular that is often incomplete or inaccurate?
Again, I don't know that I could give specific examples, but one of the things that it's important to remember that in some circumstance, there's a great deal of conflict between parties. And there are times when there can be circumstances where one party will say that the sky is blue, and so the other party will say that the sky is green because of the conflict. And so there can be significant differences of recollection and differences of opinion about the subject matter of the dispute. And so for example, with mediation, one of the fundamental rules of mediation is that you have to put everything on the table so that we can figure out what the best resolution is. Because ultimately, if somebody is not honest and forthright, it may impact the suitability of the agreement at the end. And so, you know, recognizing that now children's law can be some of the most high conflict circumstances in the legal sphere, this act very much puts at the forefront that people need to be honest and they need to be thinking about the best interests of children.
Summerside South Drive.
Thank you, Chair. So yeah, the conflict's probably the commonality there, and it can create anything incomplete or inaccurate. So point well taken. Thank you, Chair.
You're welcome. Shall Section 9 carry? Carry. Section 10. Shall Section 10 carry? Summerside South Drive.
In subsection 3, the provision says agreements are unenforceable unless they are made in writing, signed by parties and witnessed. How is this expected to happen under COVID?
So, for example, right now, we have a circumstance where, you know, the court is open and functioning. For example, the Child Support Guidelines Office is helping parties with facilitating consent orders. We have parties attending at the Family Law Center. We have physical distancing in place. The order is signed, witnessed, and, you know, these are the kind of the new reality of how things are done. We are fortunate that we have very considered recommendations from the Public Health Office and the ability to facilitate agreements and witnessing. This particular piece of the legislation is imported from the current Family Law Act. And so this is not a change to the law. This is a continuation of the existing requirements, and relates to if somebody wants to file, for example, if they come to an agreement about child support, they can file that agreement if it complies with this section with the court, and then register it with the Maintenance Enforcement Program. So we can't enforce an order or an agreement that's not signed and witnessed in accordance with this section.
Summerside South Drive.
I think that's fine, Chair, thank you.
Mermaid Stratford.
Sorry, didn't know if you were done there. So can that arrangement be made without lawyers? So if it's just, go ahead, sorry.
Absolutely.
Ready. Okay.
So you'll see that at the top of section 10, it says 2 or more persons may make an agreement. And so ultimately, if parties want to come, if anybody wants to come to an agreement about a children's law dispute, they are absolutely entitled to do that.
Mermaid Stratford.
I'm good, thank you.
Okay, shall section 10 carry?
Carry.
Section 11, Charlottetown Victoria Park.
Thank you, Chair. This is where the duty to assess whether family violence has occurred, and I appreciate how delicate and traumatic this part of it is. And so I'm wondering, and maybe this is outside of the scope, but based on the current programs and services we have, my concern is that we don't have enough programs and services to potentially deal with that. Are there more programs and services that will we need to beef any up?
So we have existing mechanisms in place through, for example, at the Family Law Center, the Maintenance Enforcement Program engages in this type of assessment. You will see throughout the Act a theme wherein what the new legislation does is create mechanisms for the court and for parties that are involved in dispute resolution to identify where there may be considerations for family violence, and for the court, for them to modify processes or to decline to provide information to parties who they have concern may use the information for the purposes of perpetrating family violence. The federal government has just put forward information that they're actually developing training for lawyers and dispute resolution professionals in the identification of family violence. And so, we are moving toward, and we have previously provided training to staff on issues relating to family violence. And so this expands and supports the important work that's being done throughout the department and throughout the court process to identify and be considerate of the impact of family violence on families, but also children.
Charlottetown Victoria Park.
Thank you, Chair. So I misunderstood this section. When I was asking about programs and services, I was thinking about outside, but this is, so thank you. And this is now probably not the place to ask, but I'm going to ask it because I'm not sure where, but is there anywhere in here that would mandate counseling for children who have been victims of family violence?
So there's no specific obligations imported to mandate counseling, but when we get to the Part 5 in particular that talks about parenting time, decision-making responsibility, and contact orders, you'll see that the court has a significant discretion in terms of making orders, and particularly in relation to Section 38 of the Act that talks about the parenting arrangement assessments that are done that would include recommendations for the court to consider about the needs of the child. That is one of the mechanisms that's established under the legislation.
Charlottetown Victoria Park.
Thank you, Chair. I'm good for now.
Summerside South Drive.
Thank you, Chair. So what's the current process for a dispute resolution professional or a lawyer to determine whether family violence has occurred? I heard you say that you've given some training and there's some more training coming, but what's the current process?
So the current process is based on the training that's provided to staff and the experience that staff have in dealing with families and recognizing potential indicators of family violence. So for example, the clinicians at the Family Court Counselor's Office who do the parenting arrangement assessments, they are experts in making assessments and recommendations for families. And currently, a number of matters that go through the family court process, there are these in-depth assessments that are ordered for families that are involved in the family court system. And so those parenting arrangement assessments would be identifying specific concerns and potential issues relating to family violence, for example.
Summerside South Drive.
Thank you, Chair. So it sounds like we're going to be adding some training for the lawyers on top of those clinicians who are fairly good at identifying this. We're expanding who can identify it.
Right. So the obligations that are created under the Act for lawyers are a self-regulated profession, and they develop their own continuing legal education. I would imagine that the Law Society will also be developing training, but that's separate from government. Certainly, when new pieces of legislation come out like this, we, as a department, look at what opportunities we have to provide training through various sources, and we are very much looking forward to seeing the training that the federal government has developed, which will be available for free online, which is always nice.
Summerside South Drive.
That's good, Chair. Thank you.
Mermaid Stratford.
Thank you, Chair. So this section triggered me on the last section, section 10, where it says only two or more people can make an agreement. Is there any, I guess, mechanisms to identify whether there might have been imbalance of power or coercion during creating an arrangement between two people in section 10?
So if you look to subsection 9, you'll see that the court retains an inherent jurisdiction to set aside the provisions of any agreement if there is concern about whether or not the agreement is in the best interest of the child, or if you look at subsection B, or clause B to subsection 9, that a party did not understand the nature or consequences of the agreement or contract. That would arguably include circumstances where their ability to understand or engage in the process may have been impacted by power imbalances or family violence.
Okay, thank
Mermaid
you.
Stratford.
That's great, thank you, Chair.
Shall this section carry? Section 12. Shall it carry?
Question on 12, if that's okay.
Mermaid Stratford.
Thank you, Chair. So the Lieutenant Governor and Council may approve rules of the court. Mandatory information session, can you just explain who receives that mandatory information session?
For sure. So one of the things that's always considered when we're reviewing legislation like this is the opportunity to consider imposing a mandatory requirement for parties to engage in dispute resolution. In some jurisdictions in the country, before you can go through the court system, you are obligated to go to mediation, for example. But we did significant consultation with family violence groups, and we heard and we were aware that not all circumstances is it appropriate for parties to engage in mediation. And so while we did not feel it appropriate to include a mandatory requirement to attend mediation, we did create a mechanism that where the court directs that parties should have a mandatory information session about what type of dispute resolution processes are available before they can get in the door to the court. That if the court, being the body that is the kind of arbiter of the decisions made under this legislation, if they create a rule of court requiring the information session, we would then, through the department, create that information session and make it available. So we are taking the lead from the court, who, as I indicated earlier, already have a fairly significant judicial dispute resolution opportunity for parties through the PMC process.
Mermaid Stratford.
Thank you, Chair. So I have a constituent who had actually asked me to bring forward mandatory mediation, and obviously there's reasons for that because she wasn't able to get the other party to go to mediation. So it created a really huge challenge for her. Still is created a big challenge for her. So this section here, that mandatory information session, is that something that somebody could, so for instance, in her case, can she ask for that to happen, or how does that get triggered? How does that get initiated?
So that would get initiated if the Family Law Rules Committee, so there's a committee established under the Judicature Act that writes the rules of procedure for the court, because the procedure in court and the process for filing documents in court and how to get into court is what we would call a judicial administration issue. That's a judge issue for the judicial branch. And so if the judicial branch creates a rule of court that requires this information session, that's when that would be triggered. Now, again, one of the things that we considered when drafting the legislation was that mandatory mediation piece. But remember, mediation has to have the kind of fulsome participation of two parties. And so if there's one party that resists, it's not really an effective process in any event. And certainly we do have a number of, we have a lot of information available at the Family Law Center through the Department of Justice and Public Safety, and free services to parties to attempt to assist them with mediation. But ultimately, not every matter that comes before the court is appropriate for dispute resolution, unfortunately.
Mermaid Stratford.
Thank you, Claire, and I can completely agree with that, because the first thing that happened when I started looking into that, because I had said to my caucus, like, I really want to look at mandatory mediation, but as soon as I talked to people who do mediation for a living, they said as soon as you put the mandatory in front of it, you failed.
Yep.
And it's really, like, that was heartbreaking to me, because I don't feel like I can help her. Right, because if two parties won't come to the table, and I can share personal experience, when you go to mediation, when it's been court ordered and you sit at that table and the person doesn't show up, you still, well, I mean, that's exactly what happened to me. It cost me $6,600 to go through to go through custody for somebody not showing up, right? And that is why I think access to justice is so important, because, like, I was fortunate because I had the means and I had the capability of doing that. But I can tell you that lawyers can't afford lawyers, and we've kind of cornered people into not being able to fight for their rights, especially when it comes to child law. And, you know, when you have somebody who is desperately asking for mandatory mediation, like, it's difficult as a legislator, because there's not much we can do to help them other than hope they come to the table, right? So that this can be negotiated. Anyway, so I'm not sure. I would love to touch base with you outside of this space to talk more about that, because I would truly love to find a solution for this person. And I just don't know if there is one, but I would, if we could do that, that would make my heart feel better. Thank you.
Section 13. Are there any questions on Section 13? Shall carry? Section 14. Charlottetown Victoria Park.
This isn't so much a question as it is a comment, and then if I'm wrong, I would love to be corrected. But I really liked this part where you mentioned something about this isn't it. Like, if there's something innovative that comes up that's changed in dispute resolution, that it can easily be added into the legislation without really changing a whole lot. Did I understand that correctly?
Yes, so this is perhaps the section of the Act that I personally am most excited about, because it allows us to be innovative. And so you'll note that this Section 14 in particular is very heavy in terms of what we would call reg-making authority. And so this is where we will establish the administrative recalculation of child support. It allows us to establish, you'll note that if you compare this act to the Custody Jurisdiction and Enforcement Act, you'll note that you don't actually see the provisions for parenting coordination in the act. That's because we are going to be moving those into the regulations, because establishing these services by way of regulation allows us to be nimble and allows us to innovate. And so if there are new mechanisms, like if you look at the family law on PEI in the past 10 years, there have been amazing things that have happened in terms of the support for people to resolve disputes outside of court compared to what the world looked like 10 years ago. And so this legislation is very much forward-facing, because if people that are smarter than I come up with new ways to help parties resolve disputes, this allows us to create new regulations to establish new classes of dispute resolution without having to come before the House with a legislative amendment.
Charlottetown Victoria Park.
I'm good, Chair, thank you.
Shall Section 14 carry?
Carry.
Section 15. Shall Section 15 carry?
Carry.
Section 16. Shall Section 16 carry? Summerside South Drive, the section is carried, but we'll go back and you can ask a question.
Well, I did say question, all right. Can you explain what this section does? What is a determination?
So if you think about this in the context of parenting coordination, a parenting coordinator is a dispute resolution professional who, and by way of the regulations, will be empowered to make decisions about the interpretation of a parenting time, decision-making responsibility, and contact order. And those decisions are binding on the parties. And so, for example, if someone disagrees that the court order, when the court order says that the child is allowed to go to hockey tournaments, and someone disagrees that that would mean, they think that means that the child is only allowed to go to a hockey tournament in Charlottetown and not Take Nish. These are things that some parties can have a significant dispute about. And so parties with a parenting coordination contract would agree that a parenting coordinator can make binding determinations about the interpretation of that order, and they both agree to be bound by that. And so this particular section, for the classes of dispute resolution professional that are empowered under the regulations to make determinations, that particular section gives them the legal authority to have those decisions be binding.
Summerside South Drive.
That's good, Chair.
So we're moving into Part 4, Section 17. Did you want to give a brief, the request was earlier, each part, just to give a brief overview of the part? Okay.
Sure, I can speak to Part 4. So currently in PEI statute book, the establishment of parentage and the presumptions of parentage are set out under the Child Status Act. So what we've done with this part is move the Child Status Act contents into this act. We've updated the language, and we've also recognized surrogacy where it wasn't recognized before. So now there is a presumption of parentage for surrogacy where there are two intended parents. And so that particular provision, what that means is that intended parents who want to have a child by surrogacy do not need to go to court to get a court order to declare the parentage. So that's the main change I would say we brought along with this particular part.
Okay, honorable members, I'm just going to throw this out there because it was asked of me. So it was requested, it was a wish of the committee that we go section by section. I'm going to ask again, is it still the wish of the committee to go section by section or part by part?
Section by section.
Okay, sure. Okay, so we're into Section 17, Summerside South Drive.
Chair, it's more of a general comment on what Blair just said there, and I have to tell you, my first instinct when I saw this section was to make sure that to go through and make sure it was very inclusive, and every time I thought that, there's something wrong here, I would find something that amended that or changed that later or addressed it later in the act. So great job in that aspect. So I just wanted to throw it out there for you.
Leader of the Opposition.
Thanks, Chair. I'd also like to make a general comment about something you just mentioned, Blair, about how this Children's Law Act incorporates a number of features of other acts that currently exist. Will we be losing some acts that currently are on the books, or will they be compatible with this one, or how's that going to work?
What we are doing with this act, and it's later in the act, is we're replacing the Custody Jurisdiction and Enforcement Act. We are replacing the Child Status Act, and we are replacing the child support provisions of the Family Law Act. So later on in the act, you will see a repeal of those particular acts and sections of the Family Law Act.
Okay, thank you.
Leader of the Opposition.
I'm good, thank you, Chair.
Okay. Shall Section 17 carry? Section 18. Shall Section 18 carry? Section 19. Shall Section Charlottetown Victoria Park?
Just a quick comment. I know the member from Summerside South Drive already kind of said this, but Blair, I just have to say in my notes how much I appreciate there's things like the way that that Blair explained this. I think that this is a really important section, and I just really want to thank you for your diligence in there. That's it. Thank you, Chair.
Shall Section 19 carry? Carry. Section 20. Shall Section 20 carry? Section 21. Shall Section 21 carry? Carry. Section 22. Shall Section 22 carry? Carry. Section 23. Shall Section 23 carry? Carry. Section 24. Shall Section 24 carry? Summerside South Drive.
So if there's uncertainty about parentage, does the court make an interim declaration to parentage until the court can decide the matter?
So the court makes a final determination as to parentage. If there's a question as to parentage, the only way that there would be an interim order that would be put in place is if it would relate to the parenting time, decision-making responsibility, or contact with a child. And so the determination of parentage relates to the obligations, either financial or of time, to parents. And so any order that a court would make in a matter under this particular piece, there is not an interim order declaring parentage.
Summerside South Drive.
In subsection 3, a child who's 16 years or older receives a copy of the court application. How did you settle on the age of 16?
That's actually from the current Child Status Act, so we just carried that over.
Summerside South Drive.
Was there any consideration to the Age of Majority Act? Does that come into play at all here?
No, I can't say that we would have looked at the Age of Majority Act.
So this would be consistent with the current process for when the court would consider engaging directly with the child. Certainly, when we get to the parenting time and decision part 5, you'll see that there are opportunities for the court to engage directly with children in court matters. But what this establishes is that when a child is 16, they're served with a notice, but you'll also see in subsection E that if the court considers it appropriate, a child younger than 16 can also be served with the application. And so there's really no kind of age limit to when the application can be served on a child. It just imports a discretion for the court, if the court thinks it's appropriate and in the best interest of the child, for them to have the application served.
Summerside South Drive.
Putting the child at the center of it again. That's fine. Thanks, Chair.
You're welcome. Shall this section carry?
Carry.
Section 25. Summerside South Drive.
Just for clarity, is the court unable to order a parentage test on its own? Or does it need one of the parties to apply for such?
So there would be nothing in this section that would preclude the court from making an order on its own motion.
Summerside South Drive.
That's fine, Chair, thanks.
Okay, so section 25, carry. Section 26, shall section 26 carry? Section 27, shall section 27 carry? Section 28, shall section 28 carry? Section 29, shall section 29 carry? Section 30, shall section 30 carry? Summerside South Drive.
Earlier in this part, we provide the different kinds of ways in which a child might be born, and this section deals with vital statistics, which manages birth certificates. Do the different kinds of births have implications on the person's birth certificate?
I don't believe so. What happens typically is that when a child is born, there's a form that's filed that the birth is registered, and the parents of the child are indicated on there. Off the top of my head, I couldn't tell you whether or not it differentiates by the type of arrangement that may have occurred.
I'm not aware that it does.
I don't think so.
It wouldn't be relevant for the purposes of establishing the information on the certificate.
Very good.
Summerside South Drive.
That's good, Chair.
Shall section 30 carry? Section 31. Shall section 31 carry? Okay, part 5. Would you like to give a brief overview of part 5?
So Part 5 is the section that governs the law in the province relating to what we would previously have referred to as custody and access, but now is parent care and time with children. So if someone is seeking an order relating to parenting time, decision-making responsibility, or contact with a child, or wanting to get approval from the court to relocate with a child, this is the section under which that would occur. The substantive changes to this piece of legislation compared to the Custody Jurisdiction and Enforcement Act it would be the best interest factors that we've previously discussed that are set out under Section 33. New, clear mechanisms for the court to consider the impact of family violence, and also throughout the section, throughout the part, the ability of the court to modify required proceedings to consider the potential impact of family violence on the parties.
Section 32. Shall it carry?
Carry.
33, section 33, Summerside South Drive.
How are these, subsection 1 here, how are these factors determined?
So the majority of these factors are directly aligned with the best interest considerations that were set out in the Federal Divorce Act. And so one of the overarching priorities of the department in presenting this draft is to ensure that we are aligned with the law that would apply to individuals who are legally married and who would be separating under the jurisdiction of the Federal Divorce Act. So we would have significant concern that there would be two different potential regimes for someone who is common law versus someone who is married. And so the federal government, through their comprehensive process, which involved consultation across the country with advocacy groups, the Federation of Law Societies, the Canadian Bar Association, there were Senate hearings and things like that. These factors were based on those considerations. We also, you will note, there is a slight difference between the factors in Section 33 of our Act versus the relevant provisions in the Divorce Act, because we did add subsections B and C as a result of our consultation with the Child and Youth Advocate.
Summerside South Drive.
Thank you, Chair. That was my next question. You identified during our briefing that you had consulted with them, so those are the two?
Yes.
Very good. Thank you, Chair.
You're welcome. Leader of the Opposition.
Thanks, and this is the section you referred to earlier when I brought UNDRIP up, Claire, so it's really just to commend you for including that reference to particularly to Indigenous children. I think it's H.
Yes.
Sorry, I've lost my page here. Anyway, thank you for doing that. And I know I asked this question earlier, and just for my own clarification more than anything, I know that UNDRIP is not specifically referenced in here, but is that something, because there are certain elements of UNDRIP, I know Canada's not yet a signatory to the document, but there are elements there specifically about welfare of Indigenous children, and I'm wondering whether you would consider at a certain later time, perhaps, incorporating that in the way that you have the Convention on the Rights of the Child, just to capture those specific and particular issues related to Indigenous children?
Right. The one thing I will point out is that, again, this legislation relates to private disputes between parties. And so two parents that have disputes about access to, contact with, and decision-making responsibility with a child. And so the cultural considerations and things like that would be part of their, what we would call a private law proceeding. This is very different than the considerations that the court would consider during a child protection proceeding. For example, where arguably the state is attempting to remove a child potentially from a cultural environment. And so, the context in which applications under the Children's Law Act come before the court are very different than the context of a child protection application. And so, often, not always, but often, if there are Indigenous parties that are before the court, there are two Indigenous parties that would be making an application under this legislation.
Okay.
Leader of the Opposition.
Thanks again, Claire. So in this section 33, again, in subsection 3, could you elaborate on the conduct you're attempting to capture under that subsection?
So this subsection 3 is a continuation of the provisions under the current Custody Jurisdiction and Enforcement Act. Fundamentally, the interest of the court is the current and future best interest of the child. And so while there may be certain things that are relevant for the court to consider in terms of past conduct, the past conduct of a party may not necessarily impact their future ability and current ability to be the person that it is in the best interest of the child for the court to consider making an order. And so this section continues that it is only the relevant conduct and not the fact that previous conduct exists. That is what the court can consider, if that makes sense.
Oh, no, it's lovely.
Leader of the Opposition.
Essence of forgiveness. I love that. Again, in subsection 3, does that capture conduct arising from issues related to mental health or mental illness, perhaps, more specifically?
Arguably, it would be any conduct.
Anything at all.
So there's no limitation in terms of what that section would apply to in terms of conduct.
Okay.
Leader of the Opposition.
Good, thank you, Chair.
Shall section 33 carry? Section 34, Summerside South Drive.
Thank you, Chair. During our briefing, you had identified, I think we all identified this as a very important change here, the provision of services in respect of a child, where one parent doesn't want the service to happen, they currently can be refused. So I'm really happy to see that in there. Under subsection 1, is this a change from the current law?
No. So there is a current presumption at law that both parties are equally entitled to access to their children.
Summerside South Drive.
Is it safe to say that this subsection only applies when the parents are together, or does it apply even when they're separated?
It applies all the time.
All the time.
Unless a court has ordered otherwise, the presumption is parties are equally entitled to parenting time decision-making responsibility.
Summerside South Drive.
Now, here we are on subsection 3 that I was just praising up there. Jeff, could you provide examples of services that might have been refused previously?
So currently, for example, a number of therapeutic providers have regulatory bodies that have specific obligations in terms of consent from parties in relation to therapeutic services. And so we heard quite a bit during our consultation about the ability for parties that may be experiencing family violence. So for example, if one parent wants the child to see a counselor and they are separated, even though the first parent may be entitled to parenting time and decision-making responsibility, without this provision, therapeutic providers may deny to provide services to the child because of the lack of consent from the other parent. This clearly sets out that second consent is no longer required, and therefore would prevent a parent from denying services to a child in a circumstance where there may be power imbalances.
Somerset South Drive. The hour has been called.
Take the chair, and the chair reports progress, and then we
Sit again.
Shall carry? Must have been home, did he? Mr. Speaker, as Chair of the Committee of the Whole House having under consideration the bill to be intituled Children's Law Act, I beg leave to report that the committee has made some progress and begs leave to see it again. I move that the report of the committee be adopted.
Shall carry? Honourable members, the hour has been called. I will call on the member from Morel Dona and the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I move, seconded by the member from Charlottetown Brighton, that this House do adjourn until December 4th, Friday at 10 o'clock in the a.m.
Shall it carry? Have a good evening, everyone. Drive safe.